Hello, my name is Kenneth Switzer and I'm the Chief Judge of the Tennessee Court of Workers' Compensation Claims, a part of the Bureau of Workers' Compensation. This court decides disputes between employers and employees when there are disagreements about workers' compensation benefits. Under the Tennessee Workers' Compensation Law, injured workers have the right to have their dispute heard here if the parties have been unable to reach an agreement on their workers' compensation claim through mediation or negotiation. The job of the court is to ensure that the workers' compensation law is applied impartially, fairly, and consistently statewide. Over the next few minutes, we will provide some insight into what to expect if you decide to request a hearing to settle your claim. We will also give you some information about where you can go for further explanation and assistance. You should not consider this video as legal advice. Rather, the purpose of this video is to provide some basic information about the court's procedures for helping settle disputes. Now, let's talk about how you could have arrived at this point.
At some point, you were injured on the job. Of course, each case is different and the facts of your injury are different from anyone else's. Perhaps you and your employer disagreed about your disability benefits. Disability benefits are the amount of money your employer is required to pay you during the time you missed from work due to the injury. Or maybe your employer didn't provide you with the medical treatment you thought you needed. Either way, to settle your disagreement, you should have prepared and filed a petition for benefit determination, sometimes called a PBD. The PBD was processed by the MOST section of the Bureau of Workers' Compensation. MOST stands for Mediation and Ombudsman Services of Tennessee. You may have called our toll-free phone number and talked to one of the Bureau's ombudsmen. They help with completing forms and can answer general questions about procedures and help in other ways to settle your dispute, but they cannot give you legal advice. Frequently, their assistance resolves the problem you are facing. While an ombudsman can be extremely helpful when you are first filling out paperwork, they are also available throughout your case to provide information as long as you have not hired an attorney. Here is their number. Jot it down if you haven't already spoken to one of them. If after talking with an ombudsman, your dispute did not get resolved, your PBD was assigned to a trained mediator who attempted to help you settle your claim by talking with you and representatives of your employer either by phone or in person. During that process, the mediator likely asked you and your employer to provide each other with various records such as doctor's notes and wage statements important to your claim. Then the mediator tried to help you and the other side settle the case yourselves. Unfortunately, if you are watching this video, it probably means you did not reach an agreement, so the mediator prepared a form called a Dispute Certification Notice, or DCN, which outlined the issues that are still not settled in a broad, general way. The mediator forwarded the DCN along with various forms and records relating to your claim to the clerk of court. At some point after the mediator filed the DCN, either you or your employer decided to bring the matter here to this court. One of you requested an evidentiary hearing. An evidentiary hearing is a hearing before a judge where evidence is given to the judge to assist in reaching a decision on your case. You either have received or soon will receive a notice of hearing, confirming when and where the hearing will take place. Since we have 8 different courtrooms across Tennessee, please read it carefully so you know where to go and when to be there. In fact, you should try to arrive early on the date of your hearing. In preparation for the hearing, the assigned judge will have reviewed all of the materials submitted to the court and will be completely familiar with the background of your case. It is important to note that just because the judge has read all of these materials, it does not mean those documents are the only evidence on which the judge will base his or her decision. We will see how this plays out in a very few minutes. The hearing is the process for you and your employer to present your dispute to the judge. Our hearing process is designed to be open and accessible even for people who are not represented by a lawyer. There are 2 types of evidentiary hearings in our court. The first is called an expedited hearing. You can request this type of hearing early on in your case to ask the judge to consider whether you are entitled to medical care or temporary disability benefits. The second type of evidentiary hearing is called a compensation hearing. In this hearing, the judge will make a final decision about whether you are entitled to workers' compensation benefits after you have recovered from your injury. In the remaining portion of this video, we will show you some examples of what a hearing looks like. Not all hearings are the same, so remember, these are just examples. The hearing is your opportunity to present evidence. Evidence can be in the form of documents, such as medical records, photographs, bills, letters, emails, text, or affidavits. Evidence also includes what people testify to in the courtroom. The documents are labeled as exhibits. Now let's see how your hearing will get started.
We're here today in the case of Gordon versus Scopes Corporation, case number 12645. Now, I've looked over all the documents that have been presented. Some of them are ready to be marked as evidence, so we're just going to go through those now. Exhibit number 1 will be the affidavit of Ms. Gordon. Exhibit 2 will be the medical records of Dr. Oglesby submitted by both parties. I do very much appreciate everyone organizing these by date and providing a table of contents as the rules provide. Exhibit number 3 will be the medical records of Dr. Snyder submitted by Ms. Gordon.
Objection, Your Honor. Dr. Snyder is not the authorized doctor.
When an objection is made, the judge will say the objection is either sustained or overruled. If the judge sustains the objection, it means it was a valid or good objection and the evidence or testimony will not be allowed. If the judge overrules the objection, it means it was not a valid objection and the evidence or testimony will be allowed.
Counsel, it appears Ms. Gordon complied with the rules. Dr. Snyder's records are both signed and she's provided a medical record authorization, so the objection is overruled and those records are admissible.
The court operates under certain rules of evidence.
The workers' compensation law requires that these hearings are conducted using the rules of evidence, and those rules require that if you want to put a document into evidence, you have to ask a witness about the document to identify it. Then you can explain why it's relevant or why it's important to the claim. If you're testifying, you can introduce a document into evidence that way, or if someone else is testifying, you can ask them those questions and lay the foundation that way. Now, the other attorney will get an opportunity to look at it, and they might object for any number of reasons. And you can ask at that point that it be admitted, and I'll make that decision at that time. Now we've got some of the evidence marked. We can move on to the opening statements. Ms. Gordon, each party is entitled to make an opening statement. These are typically brief. You don't have to do it if you don't want to, but it's just an opportunity for you to explain to the court what it is you want from the court today.
Keep in mind that this video is just meant to give you an overview of the hearing process. Not every judge allows opening statements. Some ask for them in really complicated cases, but might skip them in others. It just depends on your judge and your case. The judge will probably go over a few more ground rules in the introductory phase of the case. And after the opening statements are made, the judge will then ask all witnesses who might testify be sworn in at the same time. Now we're moving on to the proof phase of the case. This is the portion of the hearing where witnesses are called and other evidence is introduced. In a nutshell, the person who requested the hearing, usually it's the employee, goes first and presents all of his or her proof. Then the other side, usually that's the employer's attorney, presents their proof. When an injured worker participating in a hearing without an attorney presents his or her case in chief, as it's called, testifying is often a critical part. You have probably seen enough trials in movies and on TV to know that testifying means sitting at the witness stand and answering questions. If you don't have an attorney representing you, however, there is no lawyer to ask you questions to help prove your case. So look at this as your opportunity to simply tell your story. How did you get hurt at work? What happened afterward? And why did you file for workers' compensation benefits?
On Monday, March the 14th, I came into work. I started the coffee and I had brought in some donuts for Emily's birthday. We were celebrating her birthday and we were all in a really good mood, having a good time. And we had this proposal due though at noon, and so everyone started to get really stressed, especially once Mr. Bryan arrived. Okay, well, we needed to turn in this proposal, and so I had to get some paper for the copier. The copier had run out of paper. I went to the supply room to get the paper, and the paper was located on the very top shelf. And the shelf was probably about 6 or 7 feet off the ground, and I was reaching up to try and maneuver the reams of paper to get one to put in the copier, and that's when the shelf just completely collapsed and fell on my right shoulder. I told Mr. Bryan about it right away, and he got some ice for it. He sent me to Human Resources. The HR people gave me this form that I signed that said that Dr. Oglesby would be my doctor. And so I went to see Dr. Oglesby. He examined me, and he told me that my...
Objection, Your Honor, is hearsay.
How can I tell you what happened if I can't tell you what Dr. Oglesby told me?
Relevance and hearsay are probably the most common objections raised during evidentiary hearings. With regard to relevance, sometimes people want to tell every detail of their story. That's just human nature. Unfortunately, though, everybody's time is limited, and sometimes when people get into too much detail, it's easier to confuse the issue. So when you testify, help keep everybody on track with just the essential facts of what happened. Before you come to court, it's helpful to think about what you're going to tell the judge. What are the most important facts?
Let's hear what the judge says about hearsay.
Ms. Gordon, I'm going to sustain the objection. Mr. Darrow is right that that's hearsay, which generally just means you can't testify about what someone else said. Just tell us what happened and what your condition was at the time.
After you testify, the employer's attorney will have the chance to cross-examine you. In other words, the lawyer for the employer will ask you questions. You will have the opportunity to cross-examine their witnesses too. When cross-examining a witness, as a general rule, you should stick to the issues or events the witness has already testified about. A big difference between when the witness is first questioned and cross-examination is that leading questions are allowed on cross-examination, but not direct examination. A leading question is one that suggests an answer. It's okay to ask a leading question preliminarily, just to set the stage, but you can't do it on matters in dispute. Let's take a look at how this works when counsel for the employer is questioning the employee's supervisor on direct examination.
Mr. Bryan, where are you employed?
I'm employed by the Scopes Corporation.
And what do you do there?
I'm their plant manager.
Do you keep track of Scope's employees' attendance as part of your duties?
Yes, I do.
Was Ms. Gordon absent on March 15th, 16th, 17th, and the 18th?
That's
causing
correct.
her to be terminated?
I object. He's telling Mr. Bryan how to testify in the way that he's asking his questions.
I agree, and I'm sustaining the objection with regard to that last question. Counsel, this is direct examination, so please don't ask leading questions of your own witness, especially now that we know who he is and where he works.
Okay, Your Honor. I'll rephrase it.
When you're cross-examining the witness, you may ask leading questions.
Mr. Bryan, isn't it true that I texted you on March the 15th and told you that Dr. Oglesby had taken me off of work? And didn't my husband come by with a piece of paper from Dr. Oglesby telling you that I was off of work?
No, I don't remember.
You don't remember, or you don't know?
I don't remember.
You're such a liar. You've
Your Honor,
always had it
I'm
out
gonna
for me.
object. She's asking multiple questions at once. She's arguing with the witness, and those last statements weren't even questions.
Sustained. Ms. Gordon, just ask one question at a time. Also, I heard Mr. Bryan's answer, and I'll weigh his credibility along with yours with your testimony. Just let him answer the questions and take notes when you disagree. And then you can tell me about those things that you disagree on when you testify again later, all right?
Yes, Your Honor.
It's important to keep your cool during a hearing. The judge won't allow anyone to interrupt, raise their voice, or become argumentative. Our number one rule is courtesy and respect. After both sides have presented their evidence, each side will get a chance to produce additional evidence to highlight the differences with what the other side presented in their case. After each side has presented all of their evidence, the judge will allow them to make closing arguments. Closing arguments are a way to remind the judge of what he or she has seen and heard during the hearing. You will want to summarize the facts as you see them and explain why you're entitled to the benefits you want the judge to order be provided to you. This will be your final chance to tell the judge what you want the court to do for you. Let's take a closer look at closing arguments.
Your Honor, you heard my testimony that I injured my shoulder at work on March the 14th when a box of paper fell on me as I was trying to replace some copying paper. I told Mr. Bryan about it immediately, and I filled out a form to see Dr. Oglesby. Dr. Oglesby examined me that same day. He took me off of work. I texted Mr. Bryan the next day to tell him that Dr. Oglesby had taken me off of work. My husband dropped off a copy of Dr. Oglesby's letter to Mr. Bryan to let him know that I was going to be out of work for the rest of the week. And just because Dr. Oglesby didn't write it in his records that I was hurt at work, that doesn't mean that I didn't get hurt at work. I wouldn't have, if the employer hadn't denied my claim, I wouldn't have had to have gone to see Dr. Snyder. And so I think that the employer should pay for those bills from Dr. Snyder, and they shouldn't have denied my claim. I think they should have to pay for those bills, pay for my future medical treatment, and I think I should get benefits for the time that I had to spend off of work. Thank you.
Your Honor, the employee bears the burden of proof in this case, and it's the employer's position that she simply hasn't met that burden. The only proof she's provided at this hearing is her own testimony that a box of papers allegedly fell on her at work on March 14th. There were no witnesses to this. There's nothing in Dr.
The judge doesn't issue a decision right away when the hearing is over. Rather, the judge will take your case under advisement and issue a written decision or order as soon as possible. You'll get a copy of the order by email or certified mail, or possibly both. The order will summarize the facts and law and will contain reasons why the judge ruled as he or she did. The Bureau has many other resources available to help you if you do not have a lawyer. We have 2 publications available on our website. The first is a handbook entitled The Tennessee Workers' Compensation Program in Plain English that explains various aspects of the workers' compensation program and process. The second is a guidebook specifically designed to assist you in preparing for a court hearing. You can also ask court staff questions about procedure. And as previously mentioned, the Bureau's ombudsmen are available at 800-332-2667.
We appreciate your time, and I hope that you have found this video to be helpful and informative if you decide to have your claim resolved in the Tennessee Court of Workers' Compensation Claims.